calling 2015-120 State of Arkansas versus Michael Newman.
Your Honor, Mr. Newman has applied for our services and he does qualify. Your Honor, if I may.
You may.
Your Honor, Mr. Newman was, as a result of these charges, was taken into custody and it violated his parole. And he didn't show up for court because he was in the Brickies unit in ADC. As a result, he has been released from Brickies and they just transported him here as a result of that outstanding alias warrant. We do need to check his arrest date because there may be a speedy trial issue because he's been incarcerated this whole time. So we do need to set that for probably a much quicker setting. However, Judge, since he's released on parole, his parole plan is they're sending him to Omar on an ankle monitor. And what I'd ask the court to do is allow him to be released on this charge. He does have a parole officer in the office. He is going to be wearing an ankle monitor, and his parole plan is for him to go to Omar. And I'd ask that he be released on those circumstances, and then the prosecutor and I can work out this charge in the meantime. My thinking is, Judge, since he has been released on parole, is going to be on an ankle monitor, rather than coming up against the shorter time frame for a trial if he's incarcerated. If we follow his parole plan and he's released on the ankle monitor, that gives us until May for the prosecutor and I to get the case worked out speedy trial-wise.
Okay, I'm setting Mr. Newman's trial for March 21st. I'll set him for pretrial on March 17th. And if it can be arranged to have him appear sooner than that, we'll do so. So that'll be the order. I'll put him down to reappear on February 7th. So that'll be the scheduling order on Mr. Newman's case. Now, what's the proposal on bond?
Your Honor, I've talked probation parole, and he is already scheduled to be out on ankle monitor, discharged to Omar. As long as he's on that monitor at Omar, we have no objection. That continues part of his parole plan, Your Honor.
Okay. The court will make that the order of the court in terms of bond. Anything further?
No, Your Honor.
You may. Yes. 2015-154 State of Arkansas versus Devin Stetz.
Your Honor, this is the matter that I spoke to you in chambers about this morning that Mr. Etheridge and I discussed yesterday. I believe that there is an agreement that Mr. Stetz's bond would be reduced to $25,000 with the understanding that he would live and essentially be on house arrest at his mother's house, Heather Stetz.
Your Honor,
Yes, sir.
I have a question. Would I be able to work on the ankle monitor?
Well, I'm just trying to get the case. I'll address those issues, and we'll take those matters up here in a minute. Just a second. I have it down that this matter is set for trial in January.
That is correct, Your Honor. Your Honor, Mr. Stetz has been held in jail since his arrest. I believe he's been there either 10 or 11 months. I would move on defense motion to continue his January trial date. Obviously, this is a very serious charge, one that defense can better prepare for when he is out of jail, which we would anticipate would happen based upon the bond reduction that we're asking the court to approve today.
I'm going to continue it as an excluded period for trial on the week of March 21st.
That's fine, Judge.
That'll be an excluded period. I'm going to set it down for pretrial on that March 17th date. Right. Now, with respect to bond, the
Your Honor, the state's position on that bond is Mr. Cooper has correctly stated, we accept that proposal. However, this would be, he would be under house arrest. He would not be allowed to leave the home except for medical emergencies and things of that nature. There would not, it's not our intention to allow an ankle monitor to allow him to be out working. We would want him to have no access to a phone or the internet, those type of things based on the nature of this crime.
So it's, the bond is being reduced from $100,000 to $25,000 by agreement, is that correct?
Yes, Your Honor.
And that he'll be under house arrest. This isn't an ankle monitor?
He would be on an ankle monitor. He asked the question, could he be on an ankle monitor and work? And our position is he's not allowed to leave the home.
But the understanding is it'd be on an ankle monitor and house arrest.
That is correct.
And the response, the answer to your question then, Mr. Stetz, is that no, you would not be allowed to work in that circumstance. So, the court will approve that bond arrangement. The understanding needs to be that Mr. Stetz is not to leave the residence of his mother except to meet with legal counsel and or to seek medical treatment. With those two exceptions, he's to remain under house arrest.
Thank you, Your Honor.
All right. You may be excused, sir.
Thank you.